If you were involved in a motor vehicle accident, save and except for a few exceptions, your claim would be subject to a deductible. So what does that mean? Well, let me give you two examples, okay? Example number one. You're trying to settle your case, or it goes to trial, and usually there are juries involved. The jury members are not told that your case is subject to a deductible, and they may believe in your case. They may believe that your case has merits, and they may try to award you damages. They may decide that your case is fairly significant, and your case is entitled to, let's say, let's pick a number, $50,000 in pain and suffering. If that's a motor vehicle case, based on the current application of inflation, you would walk out with a net of only $12,000 because it's motor vehicle legislation. Now, same situation if your case was decided and it wasn't a motor vehicle accident case. The jury came back at $50,000. Let's say it was a trip and fall or a slip and fall accident. Maybe you slipped on ice on someone's driveway. Maybe you had an accident in a supermarket. Maybe you slipped and fell on a sidewalk. Those are non-motor vehicle cases. In those circumstances, you would not need to pay or need to. Your claim would not be subject to a $38,000 deductible. When you are going forward with a claim and it's a motor vehicle accident claim, it's very, very important to establish economic loss. So how is that established? A few situations. Number one is you're off work for a period of time, and you may get compensated by what I call, or what the courts call, collateral benefits. So that could mean income replacement benefits that would be provided through the accident benefit schedule. Sometimes people have policies or plans of short-term or long-term disability. And your income loss component would be what you lost minus any amount that you were paid. So that would be the net amount, and then there's a percentage that you'd get paid from that net amount. So that's number one. So you may have an amount that you could carry over. You have a loss. So when I mean you could carry over, you have a loss that, notwithstanding the fact that you were reimbursed from a collateral carrier, you can carry that over to the tortfeasor and present that as an economic loss. If you're self-employed, you may have a loss of business opportunity. There may be contracts that you were required to turn down. You may have been required to hire other employees or independent contractors. For example, if you're a small business and you were unable to perform the managerial skills or the labor skills that were important to your business. It may be that you didn't lose any of that income, but you are struggling to maintain your job or your employment, and the medical evidence may suggest that you're going to retire early. So we don't have mandatory retirement in Ontario, but the evidence might say that if it wasn't for the accident, you would have worked till 70 or 75 years old, but because of the accident, you're going to suffer a loss of income because of early retirement. That could be 5 or 10 years, and that's quite simple for an economic expert such as an actuary or an economist or an accountant to determine what that potential loss of income would be in the future. So what are my messages? Number one, there is a stark difference between pain and suffering damages when we compare motor vehicle accident claims and other types of claims. And those other types of claims, again, there could be slip and fall accidents, trip and fall accidents, accidents in a grocery store, private property. Number two, it's very, very important for a claimant to show an income loss claim. It's even more important in motor vehicle accident claims because the way the legislation now stands, it's very difficult to recover pain and suffering damages because of the $38,000 deductible that applies not in every circumstance, but it applies in the majority of cases.